All right, let's get real for a second. You've got this brilliant idea, right? Something you've worked your socks off to create, but now you're thinking about outsourcing production to China, and this nagging question hits you. How do I stop someone from taking my idea and running with it? Well, today we're talking about two tools that you've probably heard of: NDAs, non-disclosure agreements, and NNNs, non-use, non-disclosure, non-circumvention agreements. Here's the deal. An NDA might do the trick if you're dealing locally, but we're diving into China, and let me tell you, it's a whole different ballgame. What works back home doesn't always cut it there. So today we're breaking it all down. Which one better protects your IP and why? In this video, which is part one of our two-part series, you'll know what to slap on the table before a factory in Shenzhen touches your blueprints. But before we get into the nitty-gritty, do me a favor and smash that like button to help me out with the algorithm. And to say thank you, here's a picture of the latest technologically advanced method of shipping. First up, the NDA. You know what this is and have probably signed a few of them yourself. Basically, it's a promise. I won't blab your secrets out to the world. Sounds solid, right? It's like locking up your trade secrets in a safe. In the US, these things are golden. You've got legal backing if someone breaks the rules. But here's the twist. Take that same NDA and slap it on the table in China. Well, that's one option and certainly better than no NDA, but that might not be the best option. Why? For starters, it's usually written in English, governed by the US law. The Chinese factory? They're shrugging, thinking, what has this got to do with me? And disclosure to the public? Not their biggest game. They're not shouting your secrets from the rooftops. They're keeping them in-house for themselves. The real issue isn't them spilling the beans, it's them taking your idea and running off with it, turning it into their own payday. And your NDA most likely won't go far enough in stopping that. But hang tight, because NNNs, they're built for this exact problem. Now we're talking NNNs. What's the deal with these then? It's all in the name. Non-use, non-disclosure, non-circumvention. And this is where things get serious. It's not just about keeping your secrets quiet. It's about stopping factories from using your IP for their own gain. First up, non-use. This clause says, hey, you can't take my idea, make it your own, and start flogging it in the market. It's a direct, no-nonsense way to stop a factory from competing against you using your own design. Next is non-disclosure. Sure, this one's familiar. It stops businesses from sharing your blueprints all around. But here's the catch. Factories in China? They've got what we like to call the family business loophole. They share information within their group. So the challenge isn't just stopping them, but making sure the whole group is on the hook. And finally, non-circumvention. This is the biggie. It's like putting a fence around your customers and saying, hands off. It keeps factories from selling directly to your buyers at lower prices, cutting you out of the game. But here's the kicker. NNNs work because they're enforceable in China, written in Chinese, governed by Chinese law, with Chinese courts holding the gavel. That's how you make them think twice before breaking it. It's not foolproof, but it's your best shot. Now let me hit you with a story that'll make you think twice about skipping an NNN. Picture this. American Superconductor Corporation, AMSC for short, decided to work with a Chinese company called Sinovel to crack into the wind energy market in China. Big opportunity, right? Except there was one problem. They didn't lock down their intellectual property with the right protections. So what happened? Sinovel got their hands on AMSC's proprietary software, the secret sauce that controlled their wind turbines. But instead of playing fair, they went rogue, illegally copying software and using it to cut AMSC out of the game entirely. The result? AMSC took a financial hit of over $1 billion. Billion. With a B. Now this wasn't just a slap on the wrist. AMSC was left scrambling, their business in tatters, all because they didn't have the right safeguards in place. Think about it. An NNN could have changed the story here. A proper agreement, written in Chinese, enforceable in Chinese courts, would have made Sinovel think twice before pulling a move like that. And that, my friend, is why you don't mess around with IP protection when you're dealing overseas. Here's the key takeaways. NDAs and NNNs are fantastic tools, but they're just two pieces of a bigger puzzle. IP protection requires a holistic approach, layered strategies that work together to keep your ideas safe. Because let's face it, no single document is ever going to cover every loophole or anticipate every risk. And that brings us to the next part of this series. In part 2, we'll dive into 7 essential steps that go beyond NDAs and NNNs. practical, actionable ways to safeguard your intellectual property when working with overseas manufacturers. Stay tuned for tips that could save your business from a costly mistake. That's it from me. Let me know in the comments how you've been protecting your ideas and how. And if you found this helpful, smash that like button, share it with a colleague, and don't forget to subscribe for more tips on sourcing directly from China. I'll see you in part 2.